Okay, let's look. Now, the first pair are questions on which people do pretty well mostly. We have a fairly long, complicated fact pattern, not extremely, but fairly long, that when it comes down to it, looks something like this. At the beginning of the fact pattern, a fellow named O, who's a developer, has 325 lots on 150 acres. He's obtained approval. He's filed this plan. And he sells the first 140 lots. He didn't specify anything about what he was going to do in anything ahead of time, but he includes in each and every deed that language that you see indented there. Grantee promises on behalf of himself, as heirs, successors, assigns that he will only build single-family residence. Grantee promises to who? To grantor, who still has land, right? So grantor, and whatever land grantor still has the benefit of being able to stop any of those first, whatever, 100 and some grantees from building anything except single-family residence. But he doesn't make any return promise to restrict any future land. Boy, that's unfair, right? You can't, I can. You can't, I can. And so one thing that courts sometimes do, not with covenants at law, because covenants at law have to be expressly in writing, but with equitable servitude concept, is sometimes we imply a return promise. If I extracted a promise from my grantee, we imply a return promise if the court finds a, quote, common development scheme. And you see that discussed on background pages 59 to 66 in general, and more specifically, I believe, around pages 62 to 63. We don't imply covenants running with the land for damages, but we do imply equitable servitudes if the court finds there was a common development scheme at the very beginning, from the time that the grantor sold the first lot. Some evidence of it would be that he used exactly the same language in each deed. But there's no absolute evidence. It's going to be a question of whether the grantor had that in mind at the beginning, in which case we imply a return promise. So B, the outcome is going to turn on whether a common development scheme had been established for the entire subdivision, right, as to whether we can impose it on the rest. That's why the answer is B. Rather than, a couple you went for D, Payne should win under the application doctrine, requires construction deeds to resolve any doubt against the grantor. That's a nice rule, but that's only if there's something to interpret in the deed. There is nothing in the deed that's ambiguous and needs to be interpreted, so instead we're going to have to imply this thing. Okay. Number 22, a majority of you got right, but not quite as many. Now, what do we change in 22? Suppose that Oscar sells 50 lots during 1971, doesn't insert in the deeds any of those provisions about structures, and then Doyle purchases one of them and wants to put up a service station, and Pringle, who bought a lot from B earlier, sues. So we have Pringle against Doyle to stop him. Well, now, Doyle never made any promise to Pringle, right? But if we have a covenant and or a servitude, then it's enforceable by and against successors in interest. Are we going to be able to stop Doyle from building the service station? Is Pringle going to be able to stop Doyle? Or what, in fact, would Doyle's best defense be? It's all going to turn on the same thing as the previous question, whether there was a common development scheme at the beginning of the development. Because if the court finds there was a common development scheme at the beginning, then there was an implied return promise from the grantor to those original grantees, like Boyer. So Boyer got the benefit of O's promise, and O then transferred land that was subject to that promise to Mr. Doyle. So the outcome will turn on the concept of common development scheme, and the argument defendant's going to make is D, that the facts don't prove one. Doesn't say he's going to win, that's going to be his argument, right? Okay, now we move to what I was asked about a little earlier, right? The recording system. And let me just say about the recording system. Number one, It's got a lot of technicality to it, but I don't think it's incredibly hard or beyond any of you. And in fact, I've had people in this course who are out there doing title searches on a daily basis and having no problems at all with being expert title searchers. It's something you can do. But the concepts and how they work, the fundamental concepts of the reporting system, something that most law students never had to learn in law school. Most first-year property professors don't get to it or get to it so briefly that it's almost like they may as well not. And even if you got to it in first year, you've forgotten it by now. And then in bar review, you don't spend very much time on it. And I'm going to tell you this. It is very heavily tested on both the MBE and as a regular issue in essays all the time. So it's worth putting some time in to learn it. There are several different statutory systems called the race statutes, the race notice statutes, and the notice statutes. Race statutes basically don't exist. Don't worry about them. But most statutes, half the jurisdictions have a notice statute, half have a race notice statute. We're going to come to what they mean in a bit. But I gave you in that chart some examples of language from the statutes. And they tend to, follow fairly common patterns. On the bar exam, they are not likely to say, this jurisdiction has a race statute, this jurisdiction has a race notice statute. They're likely to give you the language from the statute and expect you to recognize what kind of statute we have. But let's back up a step as to why we have statutes and what's going on at all. That's why I've got this little chart up there. I'm not trying to be law professory and, hey, let's learn a little bit of history that's useless. I'm saying this is, I think, really the helpful way to understand what's going on with recording. You have to understand what existed before recording, because the statute changes the common law, and if the statute doesn't apply, then we're left with the common law. So you say, what was the common law that the statutes change? And the common law was basically shoe standers, right? You stand in the shoes of the person before you. First in time is first in right. If I own this watch and I convey this watch to Mark, it's now his watch. And he then sells the watch to Susan, it's now her watch. But what if, when I'm not looking, the watch gets swiped by a thief who sells it to Mark, who sells it to Susan? They don't know it was stolen. I want my watch back. It's still my watch, right? Because I had title, and the thief had no title to convey to Mark, and he had no title to convey to Susan, so it's still my watch. Same thing with land, right? If I own land and I transfer it, the person I transfer to has it. So here's the situation. If O has land and he transfers it to A, who's got the land? A. If unknown to A, O takes another piece of paper that purports to transfer that very same piece of land to B, who owns the land? A. First in time is first in right. If O, the owner of the land, I'm using O generally for the person who actually owns the land. O, the owner of the land, transfers the land to A. He no longer has title, right? A has title. If O then purports, that's the word we use, to transfer it to B, he can't. So B winds up with a piece of paper but no title. Now, that's the situation we had at common law in England, and when people first came to, let me rephrase that. When Europeans first came to take the land from the Native Americans, right? Rather than when people first came here, that'd be pretty. Okay. When the colonists first arrived, there was no such thing as a recording system. If I owned land and I transferred it, and then I purported to transfer it a second time, I could wind up getting paid twice, take that money and go off and run away with it, and the second person would be left with nothing. That's a bad system. If there's no way to check whether the land I'm about to pay money for really is owned by the person I'm about to buy money from, then people will not want to invest in land. It won't be a reliable investment. Now, in a very traditional society where people don't move around, it's probably not that much of a problem. like merry old England, but in the United States, people were moving around all the time, and it was very hard to determine sometimes who really owned a piece of land. So how do you decide whether to pay for and who to pay? Colonists came up with a system that protected people called recording. Said, if you own land, record. You transfer it to someone else, that someone else records. If I'm going to buy a piece of land from someone, I can go check whether they have good title in a place where public records are kept before I give up the money. It's a way to protect the buyer who wants to be able to rely, and it also protects the owner as long as the owner goes ahead and records. See the difference, right? So if O transfers to A, and A does not record, I always just note that as NR, does not record. If A does not record, now he's created a problem, right? He's left the record with the appearance that O owns it. B comes along and pays money for it and records. B can defeat A, because even though B is second in time, because of the recording statutes, we're going to protect someone like B. Okay? Everybody with me on the basic concept? We're changing that common law first in time rule. But when do we change the common law first in time rule? You have to read the words of the statute. Suppose, for example, we have a statute that says that unless a conveyance is recorded, I'm reading this right out of the problem, unless the conveyance is recorded, every deed or other conveyance of an interest in land is void as to whom? As to a subsequent purchaser who pays value without notice of such conveyance. A conveyance, that would be conveyance number 1, is void in relationship to a subsequent purchaser for value without notice. We call that BFP, right? So if there's a BFP, first person doesn't record it, and then we have a BFP, BFP wins. That's called a notice statute. What's a race notice statute? It's the same as what we've got here, but it would just say each conveyance that is not recorded is void as to a subsequent purchaser for value without notice who first records. We need to add a little clause on the end that says that the second person records before the first person. So if the first person was not recorded, second person becomes a purchaser for value without notice. That's not enough. They also have to record before that first person gets around to recording. So what these two styles of statute, notice and race notice statute, are telling you is they're telling you, one, what the first person has to do to make sure that he's protected. He just has to record, right? If the first person records, he's protected because there's not going to be a subsequent bona fide purchaser because he's going to be on notice because it's recorded. But if the first person doesn't record, what the second person has to prove is that he's a purchaser for value without notice. That's in a notice jurisdiction. Or in a race notice that he's a purchaser for value without notice who first records. They're telling us what that second person has to prove to win. That's the only difference between the two kinds of statutes, right? Now, as long as you know those are the things, what does that subsequent person have to prove? That the first person didn't record and these other things. Then you've got the basics down. You still have to know how to find it when looking at a series of transactions, right? And so I advise you to read carefully, however many times through reading it takes, the materials on how one actually goes about the process of title search in a traditional jurisdiction, because that's what they usually test. Traditional jurisdictions have something the equivalent of a phone book, let us picture it, right? They have an index of every document that gets recorded, listed by, alphabetically, by the last name of the grantor and the grantee, right? And you can have deeds, they take up space, but you can put in an index the last name, right, of the grantor and the last name of the grantee. And just like in the phone book, they're kept alphabetically over a period of time, for a year, for 5 years, for various periods. So how are you going to find the actual deeds doing a title search? Not by looking through great big boxes of deeds, let me find the deed, but by looking through these indexes.
and you trace a title by looking first at the grantor index. So let me take our problem in these questions 23 to 25 and look at it. And there we've got it, right? The first thing that we see is that O transfers the land to A, and A does not record. The next thing that happens is O gives a mortgage to L for money, and L does record the mortgage. Third thing that occurs is O transfers to his niece as a gift, a gratuitous transfer to the niece, and she records. After that, that first deed that wasn't recorded, then it gets recorded. It gets recorded after the deed from O to N. We have the deed from O to A finally recorded. Now N is transferring to B, and B doesn't know anything about that earlier stuff. B walks into your office and says, okay, I need a title search. Say, okay, let me do one for you. How do you start the search? Since your client B wants to buy from someone named N, what you first have to do is find out where N got the title, when she became a grantee. So you start looking backwards in the grantee index, going back through history. When did N become a grantee? You go back to that date where you see the deed from O to N. Oh, N became a grantee at this moment, right? Now there's no sense looking any further back under N's name because she became a grantee on that date. So for earlier dates, you now want to find out, well, where did O get the title? And you start looking under O's name back in the grantee index. And let's say you find that O became the grantee in 1920. Okay, from someone named P. And you trace P's name back in the grantee index, and let's say that takes you back to almost the Civil War. And let's say, okay, that's enough. I've gone far enough back under the rules of my jurisdiction. I'm way back, plenty far enough. You then start tracing forward in the grantor index. See, we're making little links in this, what they call it, a chain of title. Picture the links, right? N's link goes back to where she got it from O. O's link goes back to where he got it from, what I call him, P. Now we start tracing forward. Once O acquired the title as a grantee, we're going to look under O's name in the grantor index to see if he still had it when he purported to give it to his niece. Because what if O gave it to somebody else before the niece, and that other person might be a first-in-time person, right? So you're going to look under O's name, and you're going to find all sorts of things, like mortgages and this, that, and the other thing, and you're going to see whether they ever got cleared away, right? Was there a clearing of those things? And then it turns out that everything is fine except you find that mortgage from O to L that never got taken care of, and then you find that O transferred to N. You never saw the deed doing this check. You never saw the deed from O to A, did you? Because it wasn't recorded at the appropriate time. And you're only tracing forward during the period of time from when O acquired the title until where he gave away the whole fee simple. Once he transfers out that fee simple to niece, are you going to keep looking under his name in the grantor index? No. Because if you did that, you'd be wasting money. He doesn't own it anymore. So when A records his deed after N's deed, you have no reason to find it. You shouldn't find it. You shouldn't be looking for it. So A's deed is out of order, and therefore not part of the chain of title. And that's the answer to question 23, I'll be darned. If Barnett prevails, it's going to be because Allred's prior recorded deed is outside of the chain of title. See, A did record his deed, right? But he recorded it outside the chain of title so that B is not on notice of it. B is a BFP. He's not on notice. You all with me? As to why question 23, the answer should be A. About half of you had it, about half of you didn't. A bunch of you said on 23 that it was B because Barrett's grantor niece recorded before Allred. But that's not necessarily enough. That's not the key. The key is that his title is outside of the chain, something we have no obligation to find at all. Number 24. Assume that title was free of any claim held by, asserting that his claim was free of any claim held by Leon. Now Leon is the guy with that
mortgage that was given long ago. Is Allred going to take free and clear of Leon's mortgage? And you guys were incredibly consistent, like 80% of you said C. Leon's going to win because he recorded before Allred. Wrong. That's not why he's going to win. He's going to win because he meets the requirements of this statute. What does the statute require? Notice that, remember, Allred was first in time, right? The grant from O to Allred was before the mortgage was given. So Allred wins unless Leon can prove the benefit of the recording statute. What does Leon have to prove? He has to prove that he is a purchaser for value without notice. Doesn't matter whether he recorded. What matters, was he a purchaser for value without notice? And that's why the answer is D, not C. The first guy has to record here. The second guy doesn't have to record. He has to be a purchaser for value without notice to win. That's why the answer is D, not C. Number 25. Number 25, you mostly got correct. Assume for this question that Nease had not conveyed yet to Barrett. After Allred recorded, Allred sues Nease. Judgment should be for. And if you said Nease because she recorded before Allred recorded his, and a couple of you picked B, look at the statute. It's not the recording that Nease needs to do to win. She's a subsequent person. She needs to prove that she is a purchaser for value without notice. She's not a purchaser. She got a gratuitous gift of the land. As a donee, she can't win under this statute. Even though she recorded, she loses. Allred C is going to win because Nease was not a BFP. She didn't pay. Okay? Number 26 puts you in a different job. It says, hey, you're counsel for the State Legislative Committee, and they want a statute that makes recording of deeds, fixing priorities definite. Let's not have all this wishy-washy stuff. What's the best thing to do? And the answer to this, most you see, is as simple as make the time of recording control. That would be what we call a pure race statute. Whoever records first wins. That would make things definite, but that's not what jurisdictions have chosen to do. 27 and 28. We talked about equitable conversion last week. I always talk about it, right? We talked about equitable conversion. These are two examples of how that crazy doctrine of equitable conversion works. When people enter into a contract for purchase and sale of land, but have not yet gone to the closing, the traditional rule is this: it's as if the transaction had finished. We act as if the buyer already had an equitable right to the land, as if the seller already had an equitable title to the money, and then we figure out what funny consequences might follow from this. So in the first of these, 27, seller dies before closing. Well, even though seller is dead, we don't need seller. Remember, law of contracts, you can still enforce this contract against the estate, buyer against the estate, right? Because seller doesn't need to personally be there for this. But in any case, seller dies before the closing. His will leaves personal property to Perry, real property to Rose. Since under the doctrine of equitable conversion, his real estate, the minute he entered into the contract, his real estate became an equitable right to the proceeds. He's transferred that land from his real estate to his personal property, and so Perry should get the proceeds of the sale. We've equitably changed real estate into money. For 28, instead of the seller dying off, it's the buyer who dies off. Guess what? That contract is still enforceable by and against the estate, and buyer's heir, the person who is going to get his real estate, can force specific enforcement of the contract, and the estate would have to pay the cash because equitably it's as if the buyer already had it. So buyer's heir is entitled to specific performance, and the money would come out of the estate, assuming the money is there. Answer is A. Just consequences of that strange little doctrine.
So 27 is C?
27 is C, 28 is A, right? Those are the things that follow from treating this as if it had already taken place before they died, right?
Number 29. Back to an issue that we had last week, right? We have a contract for the sale of land. Now, this contract says that the sale will be by general warranty deed. But it doesn't matter because at the closing, the seller gave a quitclaim deed and the buyer took it. Tough luck. You should watch what happens at the closing. So now we have a quitclaim deed, and then it turns out that Owen's land was not really free of easements. There was an easement. Painter sues for damages on account of the easement. He's not going to get damages on account of the easement because it was a quitclaim deed. Painter's cause of action has to be based on the deed and not on the contract. Remember what I said, the contract, whatever the contract promised, is extinguished the minute we go through the, unless there was a fraud, right? But there's no fraud here, just we delivered a quitclaim deed, the other guy took it. Therefore, he only has the quitclaim deed to rely on. He's going to lose. He can't rely on the contract. He has to look at the terms of the deed, C. You all with me?
So,
A bunch of you said, A, existence of the easement does not violate the contract, but in fact, an easement would violate the implied covenant of marketable title unless there was an exception. Let me be clear about this. All sorts of things make land title unmarketable, including easements, covenants, servitudes. They all make title unmarketable. So most contracts for the sale of land, form contracts, say accepting for easements, covenants, they take those out of the promise, right? But if we don't have anything in the contract, easements do violate the covenant against marketable title, covenant of marketable title. Number 30. Familiar looking fact pattern, right? Because we saw it, I think it was number 20, right? Same fact pattern, just a different question. Allen sues Bates for damages to Allen's building, but couldn't show that there would have been any settling if it had been its natural condition without the weight of the building on it. Look what happens here. Number one, we're testing on a very narrow little rule. There's a series of 3 rules on what is called lateral support from the side, support from the side. 2 pieces of land next to each other owe each other what? Lateral support, support from the side. And so there are 3 rules. One says if the land is in its natural condition, unimproved, no buildings on it, if the piece of land collapses on account of the digging, there's an absolute duty, and you got to pay for any injury caused by the collapse of the land. Absolute. Number 2, if there's a building on the land, then we have 2 different rules. If there's a building on the land, and if the land would have collapsed even if there hadn't been a building, right? If there hadn't been a building, the land still would have collapsed. Then the duty is an absolute duty. How are you supposed to know whether the land would have collapsed without the weight of the building? They're going to tell you on the exam. In real life, you're going to have an expert, right? So, absolute duty, if the land would have collapsed even without the weight of the building, you still have to pay for the injury to the land and the injury to the building. 3rd rule, if the land would not have collapsed without the weight of the building, or at least we can't prove that the land would not have collapsed without the weight of the building. The weight of the building seems to have contributed to causing that collapse. Then the person who dug is liable only if negligent. So what did they tell us in the call of the question here? That Allen was not able to show that there would have been any settling if it had been its natural condition, which means that the negligence rule applies, right? He can't prove strict liability, so the negligence rule will apply. And so D ought to be very tempting. Bates, because his duty extends no further than to perform the excavation in a careful and workmanlike manner. 1983, up in my file somewhere, that was the wrong answer that I picked. I got this one wrong the first time I did it, because I was a careless reader. If you go and you read more carefully, you notice that Bates did not give Allen any advance notice that he was going to excavate. And so even though he did the excavation very carefully, a jury could find that failing to give notice was negligent. And so B is the answer. Allen, because of Bates's failure to give warning, if the jury finds that such a failure was negligent and was the proximate cause. In other words, the jury can find not that the digging was negligent, but that the failure to give notice was negligent, and that if notice had been given,
then the person would have been able to brace his building in such a way as to avoid the damage. So we have to find A, that there was negligence, and B, that the negligence caused the injury. But B is better than D. Let's look at these 10. Now, the first pair are about covenants, servitudes. Well, I don't know, maybe I'm giving something away. But we have these things, I guess I am giving something away. Owner wants to develop this residential division, and he wants to accomplish the following thing. He wants to give purchasers and their lawyers, assurance that these things will be established, that the country club, aside from country club and golf course, no land use other than residence, and I better turn off my cell phone before it winds up ringing. Nothing other than residence and the country club. Residents will all have unambiguous right of access to the club. Each owner will have an unambiguous right to transfer to a purchaser with all of the benefits, and each lot owner will be obliged to pay the annual dues. Now, if we want to accomplish this, and question 31 asks us, just, in the context of this overall scheme of things, which of the following will offer the best chance to implement, read carefully, the requirement that each lot owner pay annual dues to support the club and golf course? And if you said, well, personal contract, D will do it. No, it won't. Because personal contract to pay those dues, what is going to happen when one of the original owners sells to somebody else? Contracts are binding between the parties to the contract. If we want this thing to be enforceable against whoever happens to own the land, then we can't use personal contract. We've got to use one of those funny things that we talked about before, covenants running with the land at law, right? That's why it's got to be A and not D. Personal contract will not be enforceable against successors in interest. Number 22, same fact pattern, but now they ask, of the following, the greatest difficulty will be. What's the problem with enforcing this thing? Well, since we're trying to enforce these promises as, quote, what? Covenants running with the land at law. Remember that chart I put up last week? In order to enforce a promise and a deed as a covenant running with the land at law, enforceable against successors, what do we need? Well, we need that the promise be intended to run. That's no problem. We need that there be horizontal privity. That's no problem here between the developer and the grantees. We need vertical privity. Sell the fee simple to the grantees. That's no problem. We need that the promise be one that, quote, touches and concerns the land. And what I would imagine I mentioned last week, and what if I didn't, I'd mention again this week anyway, is that touching and concerning the land is not a problem when we have a promise that negatively restricts what I can do with my land. So if I promise in the deed, I grantee or I grantor will only build single-family residence, or I won't build any piggeries, a restriction on what I can do with the land always touches and concerns the land, always meets that requirement. But where the requirement to touch and concern is a problem is when the person makes an affirmative promise, not a restriction on what he or she's going to do, but an affirmative promise. I will mow my neighbor's lawn. That's affirmative. Or more likely, what you typically have, in the 19th century, what you had was, I will give some of the power from my water mill to my neighbors, right? I will affirmatively give them power, or I will buy power from them. Those are affirmative promises. And what the courts said in general was, affirmative promises do not touch and concern the land, generally. But then they began to come up with affirmative promises that did, and those affirmative promises are generally the kind of thing where you pay money into a homeowners association or money into some common fund to share expenses, because that's a benefit and a burden. I put the money in, but I get the benefit, right? So most affirmative promises that are going into a common fund to maintain common rights of way do run with the land. They do touch and concern. But sometimes courts have said it's too much. Sometimes country club dues might be too much. So the answer is going to be D. There's a judicial reluctance to recognize an affirmative burden to pay money in installments over time. That's going to be the issue. Affirmative promises, page 60. Tested all the time. That's the one that's often a problem. Number 33. Half of you picked B, and half of you, the other half, got it right. Okay? So I'm telling you, B is the wrong answer. And this is a very funny little question. Like, what actually answers this question directly will not be in the outline. No way this is going to be in Barbara's outline or anybody's outline. But the stuff to eliminate the wrong answers is going to be in the outline. Rogers gave Mitchell a power of attorney containing the following provision. There you see the provision, right? Indented. Mitchell conveyed part of Rogers' land to Stone by deed, customary form containing covenant's title. Stone sues Rogers for breach. Stone sues Rogers, but Rogers didn't actually give the deed. Mitchell gave the deed. Outcome will be governed by, and nobody picked A. Sometimes I get some people picking A. Deeds without covenants are effective to convey realty. Answer is, it won't turn on that because deeds without covenants clearly are sufficient. We have a thing called a quitclaim deed. But half of you went for B. The jurisdiction views the covenants as personal or as running with the land. Now see, that's a very appealing wrong answer because in fact, the covenant to sell and convey is one of those covenants of title that we often see in deeds. And in fact, some covenants are personal and some covenants of title are personal and some do run with the land. And you'll see that discussed where they discuss titles of covenants of title. The covenants that run with the land, covenants of title that run with the land, are the future covenants, not the present covenants. If you know what I'm referring to, there are 3 present covenants listed in your outline. Right to convey, covenant of cease, and covenant against encumbrances. Those are present. Those either are breached at the moment the deed is handed over. I deliver the deed to Mark and I say, I have the right to convey, I am seized, and there are no encumbrances. Right now, it's a promise about how things are right now. That covenant is personal to Mark. I'm only making that promise to him. He's the only one who can sue me. But if I gave a full-fledged general warranty deed and had all those other covenants, covenant of quiet enjoyment, covenant of warranty, and the covenant of further assurances, those are promises about what's going to happen at some time in the future. Not about what's true now, but about the future. And those covenants of title do run with the land, not just to the original grantee, but to people he conveys to. But that's irrelevant to this question. That's not the issue here, right? We only have one covenant of right to convey, and that's personal. The question is whether the attorney had the right to include or the power to include covenants in the first place. Because Rogers himself did not write these covenants. Mitchell wrote these covenants. And when Rogers gave Mitchell the power, quote, "You're authorized to sell and convey my real estate," does that agency include the power to give covenants of title? I don't know. I don't care. That's going to be the issue we're going to interpret under the laws of the jurisdiction, whether the power that was given to the attorney includes the power to include those covenants, and so the answer is D. As I said, literally, I'm sure you're not going to find anything in Barbara's outline that's going to say D is correct. What you do have in Barbara's outline is enough to know that B is incorrect. See, much harder than the LSAT, huh? Number 34. Number 34 is a question that I don't think I've ever had a class do much better than about chance on. And literally, there's nothing explicitly on point in the Barbary outline, but I think I can help you with this so that you'll understand it, I hope. We have these two guys, Allen and Barker, and they are tenants in common of a 10-foot wide strip down the middle of their property. Picture this, see? A owns this land, B owns this land, and this 10-foot strip, they happen to own as tenants in common. And they use it as a driveway. And they get worried that, remember what we talked about last week, when people own land in common, there's a right to partition, to sell it and have it partitioned or to split it. So they start worrying, we don't want this thing partitioned in the future. And they come into your office and say, how can we avoid a partition problem in the future? Well, if you said, well, we can, quote, covenant against partition. Dare I say this? When one marries, one promises forever. And then sometimes you partition. It's called a divorce. The courts in this country don't say stay together and kill each other. They say, okay, we'll partition. It's the same thing. We're not going to make people stay in a land relationship. We're going to partition even if they promise not to. Not going to enforce it. Won't work. Then the one that lots of people try. How about an indenture granting cross easements in the undivided half interest of each? Number one, when you picked that, you didn't know what the word indenture meant, did you? So you said, hey, if I don't know what it means, it's probably right. That's not a good reason. Okay. Number two, it says granting cross easements in the undivided half interest of each. Do you know what that means? Here's what it means. It means they still own the whole land together, but they give each other easements in the land. And if there's one rule that's really, really, really clear with easements is you can't have an easement in land where you own the fee. So if you are a joint tenant, a co-tenant of any kind, you can't have an easement in your own land. You can have a driveway across your land, but you can't have what we call an easement. So a cross easement that they each give each other in land that they jointly own is worthless. It doesn't mean anything. Can't do it. Now, partition into two separate 5-foot strips. Gee, you know, people who own land in common can agree to partition. This 5 feet to me, this 5 feet to you. Now they each own 5 feet. And they give each other an easement in the 5 feet they don't own. It works. It's like a party wall, right? If we have a wall on the borderline, you see there's a little section in your outline on party walls. If there's a wall that goes a couple inches onto each side, right? The person who owns the piece of land on which part of the wall is, that person owns that part, and the other person has an easement. So you own and have an easement in the other half. That's the way you do it. So we start off, I told you that you can't have a rule, you can't have an enforceable covenant against partition. And then you have a creative lawyer that says, well, if I can't have a covenant against partition, can't I just split the thing into two and then give each a cross easement? In the other half, yes, you can. Now, there's no way to partition it. We avoided the risk of partition. That's the answer. But see, boy, that is a tough question, isn't it? Now, number 35 also turns out to be pretty tough for people, I'll say. It's another Recording Act kind of thing, right? Because, in fact, let me put up, I think I've got a little diagram on it. Yeah, I think this is it. Okay, in number 35, at the beginning, O conveys to P, but P does not record, right? Price accepts the quitclaim, puts it in a safe deposit box. We know he didn't record. Owen was indebted to Kreider for $35,000, and in 1971 he delivered a deed purporting to convey it to Kreider in exchange for a release. So we have O to P followed by O to Kreider, and Kreider records. Price then records late, right? And we have a statute that says you need, if good faith and value are elements of the junior claimant's priority. What's the best comment about the situation? Remember what we were talking about in the first part of the class. First in time person, that would be Mr. Price, would win at common law because he got the deed first. The second in time person, Mr. Kreider, can only win if he proves the benefits of the recording statute. Since Price was foolish enough not to have recorded right away, Kreider can win if he's a BFP. Is Kreider a BFP? I don't know. You know, there was nothing recorded to put him on notice, but did he pay value for this thing? What he did was he released an existing debt. It said there was an existing debt that was released. Release of an existing debt is good enough for value in some jurisdictions, is not good enough for value in other jurisdictions, and it tells you this on about page 90 of your outline. It's not the same as, remember in the previous group, Mr. whatever his name was, Leon, gave money at the time he got a mortgage. He gave actual money right then. But Kreider did not pay actual money, cash in hand. What Kreider did was he released an existing debt. Is release or cancellation of an existing debt value for the statute? Depends on the interpretation of the statute. The answer is B. Now, Bunchie went for C. The outcome will turn on whether Price paid value. How do I say this? No. No, 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 no. Definitely not. First-in-time person, we don't care whether that first-in-time guy Price, we don't care whether he paid value. That's irrelevant, right? Only person who ever has to pay value is the second-in-time person, right? Second-in-time person under the statute has to prove to get the benefit of the statute that is a BFP. First-in-time person does not have to have paid. He just, to protect himself, he has to have recorded first, right? So that's why C is absolutely incorrect. How about A? Price can't succeed because the quitclaim through which he claims prevents him from being bona fide. Again, if I could just repeat a whole series of no's. There are a couple of, just so many things wrong with that answer if you think about it. Number one, Price is the first in time. The first in time. I want to absolutely be clear on this. The first person to get that land from O, the first person to get the deed from O, does not have to pay, does not have to be without notice, doesn't matter whether it's a quitclaim deed, a warranty deed, none of that matters. He's first in time, Price. Price is going to win if he either records before Kreider comes along, or if Kreider can't prove the benefit of the recording statute. The first in time guy never has to pay value, and whether he had notice is irrelevant. So A and C are just wrong. Price's failure D to record stops him. It's not a question of estoppel, it's a question of applying the words of the statute. Okay? Give this a lot of thought as to how we apply the statute. 36 and 37. 36 and 37. We have, this happens to be a fact pattern from the granddaddy old 1972 exam. But they ask, not a lot, but occasional questions about land description. Not a lot of questions. Read the stuff about land description. Here we have a grant of all of my land known as 44 Main Street. And the description of 44 Main Street, folks, is going to be sufficient even though the acreage didn't match what the deed said. Acreage is the least important thing in a deed. The important thing in a deed is that the deed have something from which we can exactly and without doubt determine what the land is, a description that's exact. 44 Main Street is probably perfectly sufficient, despite the fact the acreage doesn't match, no problem. But what about the description, number 37, of Pat's farm? Many of you said, B, sufficient, there's no ambiguity on the face of the deed. Well, you're certainly right that the problem is going to be whether there is any ambiguity on the face of the deed. And I know some of you went to law school because you said, I don't want to do math, and I don't think you have to do any math in law school, and that's fine. You do have to do some math as a lawyer. How do you have to add up your bill, but maybe just hire other people to do that, right? This is geometry. And I know it's a long time since I took geometry. Long time since you took geometry, but I know they told us back then, what is a line? The line is defined by 2 points, and then it's an infinite number of points, right? A line contains an infinite number of points. If I have a line, whatever that line is, it's got an infinite number of points. And this description tells us to start measuring the 200 acre, or the part that's being granted. It's a 200-foot square starting on the north boundary of Julia Brown's property. But where on the north boundary do we start? It doesn't tell us. And since Julia Brown's property has a line to the north, we need to have something that tells us the exact point to start from. How would one do this in a land description? You would say the northeast corner or the northwest corner of Julia's property. Or you would say a point that is 20 feet to the east of the northwest corner of Julia Brown's property, or something that lets you determine the exact starting point. Here, we don't have that, so in fact, it is ambiguous or vague. We don't know where to start it. The answer is D rather than B. Go back and study geometry. Okay, that's a joke. You do not need to go back and study geometry. Number 38. Guys did about 60%, not bad. It's on stuff that we've talked about before, though, to some extent. Chase is the seller and Scott's the buyer. They enter into a written contract for purchase and sale that doesn't say anything about the quality of title to be conveyed. Is this contract going to be enforceable? A, that's an answer that a bunch of you pick, always. Maybe. Is it absolutely enforceable by both parties? Well, it's enforceable by the buyer, but it's only enforceable by the seller if the seller has marketable title. Because since the contract does not specify the quality of the title, what did we say earlier? If the contract is silent, we imply that the seller makes a covenant that he will have marketable title by the time of the closing. And we know this contract was silent, so therefore B is better than A. Chase will be required to convey a marketable title. That's certainly true. Whereas A is maybe true, but not for sure. B is more certain. What about D? Chase will be required to convey only what he owns at the date of the contract. That's false, right? D, if you picked it, says to me that you still have not taken full grasp of that concept, marketable title, pages 71 to 73 of your outline. If people enter into a contract to buy and sell land, and if the contract says nothing about what title the seller will give at the time of the closing, the courts imply a promise, a covenant, to convey marketable title at the time of the closing. So D is false, right? Can you have a contract that doesn't promise marketable title? Sure, but you'd have to be explicit in the words of the contract. I contract to sell you all of my right title and interest in the Brooklyn Bridge, but I don't promise you that I have any. But I'd have to put it in the contract that I was not going to promise a marketable title. If I don't say anything, we imply marketable title. Most contracts actually say marketable title, right? But if it doesn't say anything, we'll imply it. So the answer is B. 39 and 40. It's another example of my beautiful artwork. But we have these three parcels, right? And at the beginning of the fact pattern, O owns the whole thing. He sells the one parcel to A and the other parcel to B, and he keeps the third parcel for himself. And then A and B, for question number 39, A and B have put up houses, and they built a common driveway from the street to the rear of their lots, and they exchanged right-of-way deeds. That's easements, right? Right-of-way deeds by which each of them conveyed to the other heirs signs forever an easement to continue the right-of-way, and they're recorded. Now, new street comes in the back. When the new street comes in the back, one of them says, hey, I don't need that driveway anymore, let's get rid of it. The other says, no, I don't want to get rid of it. So, B brings a suit to enjoin A from interfering. A wants to get rid of the driveway, B doesn't. Can B get an injunction against A and blocking the driveway? And And a bunch of you said A, Akers wins because termination of the necessity terminates the easement. Wait a second. This was not an easement created by necessity. If it was an easement created by necessity, then it could terminate on account of the termination of the necessity. This was an easement created by what? Express deed. Expressly created easements don't terminate just because the necessity for them went away. Then a few others of you went for Bell wins C. I love this. I love it because it's my chance to show that I can actually sometimes pronounce. Bell, because an incorporeal hereditament lies in grant and cannot be terminated without a writing. Who here would like to explain to us what an incorporeal hereditament is? Don't pick an answer if you don't know what the hell it means, please. Unless you're really sure the others are wrong, right? This is an incorporeal, yeah. Yes, it's like a ghost, right? An incorporeal hereditament, right? Okay. But an easement can be terminated without a writing. It's false to say that an easement, an incorporeal hereditament, as it would be, cannot be terminated without a writing. Easements can be terminated by abandonment, by prescription. They don't need to be terminated by a writing. A writing is often what terminates. D is the answer. Bell wins because the mere removal of the need does not get rid of an expressly created easement. D, right? Number 40. Action by Bell to enjoin Ogden. Now Ogden, our original grantor, wants to build, and it's going to block. Bell has this beautiful picture window overlooking this beautiful lake, and Ogden is going to build right in front of him. And so B would like to stop O from doing so. On what basis? That he has an easement for a view. Now this is something that I don't know why, because this is such a basic rule, it's tested fairly regularly, but we have a rule in our law that says easements for light, air, and view. You can have an easement for light, you can have an easement for air, you can have an easement for view, but you can only create them expressly. We never imply them. So implied easements, prescriptive easements for light, air, and view? No, only if they're expressed in a deed. If I build my house to get this beautiful view of the lake, and I know that owns that piece of land between me and the lake, and I have some concern about maintaining my view, I can go to Mark and say, Mark, pretty please give me an easement that says you will not block. And Mark can say, well, pretty please pay me. And we can negotiate a price, the value to me of having the view versus the value to not being able to build on that part of his property. Say, look, it's valuable to me to be able to build there, but I will agree not to build on that part of my property if you pay me $50,000 or whatever is the particular requirement. Okay? No implied easement for light, air, or view. You can have an express one. That's 40. Question, where do you even start? I'm going to give you the answer packet, so I want you to really look at these, and it should give you some sense of confidence that you can do better than people taking the bar. It was a tough question. People didn't know what to do with it. If you approach it in a logical manner, you'll figure it out. You are to ask or answer whether Barr will succeed in recovering damages from LeMaster or from Freeman. That's the call of the question, right? Barr sues LeMaster and Barr sues Freeman. That's ultimately what you have to answer. But remember what I've said before. You know, even though that's ultimately what you have to answer, you may have to go through other things to get you there, right? Barr got the land from LeMaster in a quitclaim deed. LeMaster got the land from Freeman in a warranty deed of sorts, right? There were at least some warranties. So we had Freeman to LeMaster,
with some warranties. We had LeMaster to Barr in a quitclaim deed. Barr wants to sue LeMaster, Barr wants to sue Freeman, right? Now I want to ask you, if you think about this, it's like in those tort cases, you're going to win in torts, well, what's the name of the tort? Well, in this case, Barr is suing LeMaster and Freeman for what? It's nice to know that it's a quitclaim deed or a warranty deed, but what is he complaining about? What's Barr's problem? Why is he upset? Is what you got to think about. Now you start reading through the facts to ask, what is he upset about? And you look at the beginning of the fact pattern, and an amazing number of people skip over this. Even if you don't right away figure out what its relevance to answering the question is, look at what we've got. LeMaster owned Lot 8. It says was the simple owner. We're not it means fee simple. I think I left out a word. At the time the building was built, John Freeman was the owner of Lot 8. Freeman constructed on 8, entered into, here's key, party wall agreement. Penn and Freeman entered into a party wall agreement in which they agreed to contribute half of the expenses of constructing, maintaining, and if required, rebuilding this party wall. And it said this agreement is to be binding upon heirs, successors, devisees, construed as a covenant running with the land, and it gets recorded. See, all of this is what took place between someone named Penn and our original grantor Freeman. If you don't know right away what the problem is, you've got to figure that all this stuff can't possibly be there if it's not intended to be discussed. As you're working this problem through, it's not immediately apparent why it matters that Freeman and Penn entered into this agreement. You've got to figure all these facts are there for some reason. If you're not sure what, at least discuss, is this, what would it be? A covenant running with the land at law. If you discuss whether this thing is an enforceable covenant running with the land at law and run through the elements that we talked about earlier, you are writing a passing answer already, even if you don't know anything about the rest of it. People skipped over that. They didn't know what to do with it, okay? The promises exchanged between Freeman and Penn may be enforceable as a covenant running with the land at law if there was horizontal privity, there's vertical privity, the promises were intended to run, and they touch and concern the land. Horizontal privity, Freeman and Penn, can't just be neighbors, but it's a party wall. Cross easements, just like we have with that right? And if you look in Barber, you'll see there's a paragraph on cross easements. A party wall says creating cross easements, and the cross easements give you a basis for finding that there's privity between those people. They each have a land interest in the other's land. And this promises pertain to those easements in the party wall. So we have horizontal privity. It's really easy this was intended to run with the land. You're going to make some hay just by saying it was intended to run with the land, as is shown by the fact they said, we intend this to run with the land, right? Just, do it. The question is going to be, the dubious one is going to be something we talked about earlier today, remember? Is this a promise that touches and concerns the land, given that it's an affirmative promise to pay money or to build a wall and to share the expenses? And if you state the general rule is, no, affirmative promises don't, but the special rule is if the affirmative promises are for mutual benefit, like sharing the expense of the party wall, then it very well may touch and concern and be therefore enforceable as a covenant running with the land. Now think about it. If it's a covenant running with the land, who is going to be bound by it? Any successor who's on notice. Like when Freeman sells to LeMaster, since it's recorded, LeMaster is bound. When LeMaster sells to Barr, since it's recorded, then Barr is on notice. So Barr is bound, in all likelihood, by a promise that if anything happens to this party wall, he will pay for the rebuilding of it. That's why he's got a cause to be concerned. He's bound by a promise that he wishes he wasn't bound by. Once we see that, now you can go to the other part, Barr against LeMaster.
all you need to know is that with a quitclaim deed, the taker can't sue based on the deed because there were no promises in the deed. LeMaster didn't promise Barr that this thing was free of encumbrances, so he's not liable. Even if Barr is bound, he's not liable. What about Freeman? Remember, we had that little issue come up in the multiple choice earlier today. The present covenants of title, 3 of them, those are personal. Those can only be enforced by Barr, remember, or by LeMaster. Remember that discussion? Covenant of season, covenant of right to convey, covenant against encumbrances, those kinds of things. The only person who could have brought a suit against Freeman for breach of those would have been LeMaster. Doesn't do Barr any good. But the 3 future covenants, right, covenant of warranty, covenant of further assurances, and covenant of quiet enjoyment, those promises about the future run with the land to successors like Mr. Barr. So Barr can sue back against Freeman in the future if those 3 covenants are ever breached. Final question, does the existence of the covenant about the party wall breach any of those land title covenants? My answer, you'll see in my answer to the essay, is no, not yet. There's no breach until Penn comes after Barr and says, give me some money. Until Penn comes after Barr and says, give me some money, there's no breach of those covenants. We have to wait for Penn to come after Barr. I believe that's the right answer. And we're way beyond the 7-pointer, but I want you to see step by step. The call of the question breaks it down significantly, using the covenant running with the land to organize how we deal with the relationship between Penn and Freeman. Organizes another part of the answer. See, you don't have to get to, I believe that my answer is correct, and I assure you, I have never researched it, I'm never going to, right? I wrote it, I was done. But even if you don't see how all the parts quite fit together that way, you can get pretty far along by just taking parts of it and saying really good things about them. And if in the process it all falls into place, all the better.